Hey everyone, Dustin here from Law at Your Side, and a brand new law just got passed that deals with COVID-19. Let's talk about it today. So a brand new law just got passed dealing with COVID-19, and I'm going to go through the ins and outs with you here today to see if it's something you apply for or just for your general knowledge and purposes, if that's why you're watching this video. So if you remember earlier in 2020, the California governor issued an executive order giving certain criteria, and if an injured worker fits those criteria and they get COVID-19, it will be presumed that they will have gotten it at their workplace. This is a big law because previously, if someone, and even right now, if someone gets COVID-19, we don't exactly know where they got it from. So this executive order that was passed was done in a way to essentially give the workers the benefit of the doubt. But a new law was passed by this legislature, SB 1159 and AB 685, that codifies what the governor said, but also adds some additional criteria. So I'm going to go over everything with you here right now. So let's just really briefly review the prior law because this new law builds upon it. So let's review the executive order, and this new law is going to build upon this. So I got my little chart here, but this is the prior law, okay? And what the prior law says that you have to be at a physical location working, and what that basically means is either the job site or the excuse me, the employer's premises. It does not mean home. So if you're working from home, you do not apply under this presumption, okay? So at a physical job site, okay? And you were there within 14 days. I'm just going to write like this, much easier. You were there within 14 days before you got diagnosed with COVID-19. So if you were at a physical location, you got diagnosed with COVID-19, and that happened within 14 days of while you were there, that could trigger the presumption that you got COVID-19 at work. This applied, the executive order applied to any and all employees in California, okay? And but there was a specific date here, because this got passed, I think, in March or maybe even April, I don't remember exactly. But it applied for injuries occurring between March 19th and July 5th. So between March 19th, July 5th, if you got any employee got diagnosed with COVID within 14 days of physically working at a location, their claim would be presumed to be a workers' comp claim. And what that basically meant is the insurance company had 30 days to accept or deny, but unless they had evidence to really deny it, they had to basically accept it, okay? That was the old one. But the big question was, what happens after this? After July 5th, what happens to everybody? So the new law that was passed now applies to July 6th, right after 2020, all the way through, let me get the dates right, January 1st, 2023. So the new law is going to apply for everybody diagnosed after this date. And what is the new law exactly? No longer are any and all employees covered. Is actually very they've broken this down into two areas. So if you are a firefighter, we'll draw a little fire here. Firefighter. That's not a great fire, but you get the idea. If you are a police officer, draw a badge. Police officer. Or if you are a healthcare worker, we'll draw a cross. Forgive my awful drawing here. But if you are a firefighter, police officer, or healthcare worker, and what healthcare worker, we mean nurses, work in the emergency room, hospital, home health agencies, or in-home support services, anything in that area, then you are going to have the same exact presumptions here. Meaning, if you were one of these and you're physically working, diagnosed with COVID within 14 days, you will have the same presumption. They will have 30 days, a rebuttable presumption that you got COVID because of work. But if you are not one of these, then you fall into a different category of people. And what this new category is, not the greatest rule, but basically it says they look at, say, was there an outbreak at your place of employment? Was there an outbreak at your place of employment? And what an outbreak they're sort of defining is to be 4% of the employees working there. If 4% of the employees working wherever you're working also got COVID, they're going to say, yes, there was a COVID outbreak, and yes, you are going to also get the presumption that your injury was work-related. 4% or more. Now, there's a little caveat. So if your location where you're working has 100 employees or more, it's 4%. If it's 100 employees or less, they're going to say it's 4 people. So is that the same thing? No, not really, because if there's 100 people, if there's, let's say, if there's 100 people and you get 4 people there, that will be 4%, so that you'll have a COVID outbreak. But if there's only 50 people, it still says 4 people, which in that case would be 8%. So it doesn't really make sense. They also don't specify what if you only have 3 people working there or 4 people working there. It says you have to have 4 people who tested positive at a company with 100 or fewer workers. So that part of the law doesn't make total sense. It's not really clear. But basically, this is your magic number, 4% of the total workforce at that location, or 4 people if it's less than 100 employees. This is greater than 100, and this is less than or equal to. I believe less than or equal to, and let me not... Yeah, exactly. Less than or equal to 100. So if that happens, then you'll have the presumption of workers' comp. And then there's one last caveat here. Instead of 30 days, it would be 45 days for them to accept or deny your claim. So briefly to review again, if you are a firefighter, a police officer, a healthcare worker, basically nothing changes. They've just extended this presumption all the way out through 2023. If you are not one of those 3, though, you don't get the presumption unless 4% or more of your company has had an outbreak. If you have more than 100 employees, or 4 people at your company if you have less than 100 employees. If that has happened, you'll get the COVID presumption. It will presume that you got COVID at work. If it does not, they won't necessarily presume that you got COVID at work. Now, that being said, that doesn't mean they're not going to deny your claim. We have some COVID claims. A lot of them have been accepted. So doesn't necessarily mean they're going to deny it, but just something to keep in mind, and just explaining the new law. Okay? So if you or someone you know got COVID-19 and you think it may be because of work, if you're not sure if you fit within these presumptions or not, please do give us a call. We'd be more than happy to talk to you, and if it's a case we can take, we would be more than happy to take it on. Thank you so much, and please subscribe to this video, give us a thumbs up, and share with family and friends, and also give us a call, 818-861-9675. Again, 818-861-9675.